is on the panel of Delhi Sikh Gurdwara Management Committee, Horizon Panchayat Committee, Meghalaya, and he is working for prison reforms in Tihar jail and is quiz master in many institutions. Mr. Vora has appeared many important court matters like Netflix, Amazon, etc. He has also contested Kaun Bane Crorepati season 9 episode 1 in 2017. He had been a speaker in various moot courts. So after that, so how are our courts working? Now this is a question arising these days. So now I request Mr. Hora to address the participants. Mr. Hora.
Dr. Jyoti, is the voice clear? I hope the video and audio is okay so that we don't have technical.
Yes, sir. Your audio and video is clear.
Yeah, I'd just like to reiterate the request as made by you that I'd request all the participants to put their microphones on mute. Disable your microphone so that we would not have technical interjections right in the middle when me, or for that matter any other addressee is addressing. So hello everybody, my name is Harpreet Singh Hora. I am currently practicing in the Honorable Supreme Court and the Delhi High Court. Before we begin, my sincere word of gratitude especially to Dr. S.S. Saluja, Dean RIMT School, Dr. Jyoti, and all the participants for joining us. Gentlemen, so I would be talking for a few minutes on 5 different aspects. When it comes to judicial development, I'd like to begin with what is the legislative framework on which these developments and specifically the policy making by the government is going on. Secondly, I'd also be touching the matters wherein judicial activism has been sought by the petitioners in the Honorable Supreme Court of India, or for that matter, the Delhi High Court. Then thirdly, I'd be touching on the topic of what is the way ahead, because as Dr. Jyoti has mentioned that the Supreme Court has barred physical entry of the litigants, for that matter, the advocates. Then we have switched to technological upgradation, for example, the virtual courts. Otherwise, on policy, on legislative front as well, the limitations have been lifted, or for that matter, extended for a certain period of time. So I would also be, along with that, touching on the point that the petitions wherein some policy decisions were sought to be taken by the petitioners, wherein they invoked either the powers under 32 or 142 of the Honorable Supreme Court of India, wherein the Supreme Court's response has in some places been appreciated by certain aspects of the society, but in some other matters as well, wherein the Supreme Court has exercised judicial restraint. Fourthly, I'd also be discussing, in case time permits, what are the advantages of how the cases are now being taken in virtual courts, and from my own experience of practicing in the Honorable Supreme Court, that what are the disadvantages either on the sides of the litigants or on the side of the court or on the side of the lawyers, because it is very important to have this practical aspect into play, for the reason that when Honorable Supreme Court says that technology is here to stay, so we have to see that this era of technology in which we have ushered is not the advent has not taken place because we wanted it to happen, but we were somehow under an impression that we could continue with the judicial setup we had, but then eventually COVID-19 happened, and then we have shifted from the general setup of judiciary into the judicial developments, which are more dependent on the technological front. So to begin with, what is the current legislative framework? Because when we talk about the judicial developments, it is imperative to first talk about the legislation. So there are countries, for example, in case the time permits, at the last I'd be discussing certain legislations about Australia, England, Canada, and a case of judicial restraint in Pakistan as well. But as far as the case of India is concerned, firstly, when we talk about what is the legislative architecture that we have on which these development of cases have to take place. First thing that would come into this, if you ask anybody, is the EDA, that is the Epidemic Diseases Act. Now, the battered sections, for example, 144 or 188, for example, the DGP of Police, ex-DGP of Police, Mr. Vikram Singh from Uttar Pradesh, had, I guess, 15 days ago, approached the Honorable Supreme Court talking about those FIRs filed under EDA coupled with the Epidemic Diseases Act, coupled with the sections of disaster management, coupled with 188 of the IPC, coupled with 144. Although the Supreme Court has declined to interfere, because obviously there is also one aspect that constitutional courts are rights court and they cannot be supplanted as a trial court for that. Although that is the opinion on which the Supreme Court has given this decision. So when it comes to EDA, now this law goes back to 1897. It's not just to give a 30 seconds brief. It started with the problem of bubonic plague in Bombay. This law was brought into picture, the British rulers, the British legislative setup. But unfortunately, neither they could contain the plague, neither they could plug in the problems. And this plague in 1897 traveled from Bombay all the way to Mysore, that is current Karnataka, specifically Bangalore. So it means even in there has been around 123 years, more than a century for this ETA. So firstly, when we say that we have to discuss about the judicial developments on that front, why would you say that? First question that has arisen in the civil society is whether this act or the current legislative framework is deficient or not. The answer to this, in my opinion, when we specifically talk about judicial developments, in light of the developments we had post 1970, specifically under Justice Arthwati and under Justice V.R. Krishna Iyer, then I'd say that yes, certain judicial developments are still needed because this act is deficient for several reasons. Secondly, the situation in 1897, or for that matter in 1947 as well, or 1950 when the Constitution came into picture fully, the situation was that we had this notion that when it is read vis-a-vis Article 21, what we would be dependent on is the procedure established by law. Now, since January 1978, that is the Menka Gandhi case, we have a paradigm shift from procedure established law to procedure established by law, along with the fact that procedure has to be just, fair, and reasonable. Read with Article 14, this act, I believe, is deficient because, firstly, there are no extant rules and procedures whereby we have a benchmark. For that matter, the judiciary has a benchmark that when a particular disease needs to be declared as an epidemic. This is also one of the problems which Canadian legislations have suffered. But ultimately, for example, in the case of national concern, there is this concept of federal legislation versus provincial legislations, which I traveled from England to Canadian jurisprudence. The concept of national concern had been a problem for Canadian judicial development as well. The courts came into the picture, the courts plugged in this loophole, and then they had set up a benchmark what would qualify as a national concern. Now, in the EDA Act, we cannot have a judicial development until and unless we have a benchmark for that matter. And this is where the Act mainly lacks to declare. Secondly, you see, as I have said, there is no benchmark even to declare what is an epidemic. Now, there is a word, for example, if you say the word is dangerous, there is not even laid down specific guidelines or for that matter, regulation that what would you call as dangerous. So that obviously is an antithesis of 14, 19, and 21 also on one aspect. Then there is when I say that the procedure has to be just, fair, and reasonable, you see that this act gives ample powers to the state and central government. But when there is an executive authority whose action is brought into contest before a judicial setup, before a judicial bench, it also becomes necessary for the judicial side to see what are the so-called ample powers we say that have been given to the states and for that matter the central government, but there are no laid down regulations as to what steps specifically are needed by these governments, and for that matter, any level of authority in preventing the epidemic, controlling the epidemic, and also it does not explicitly lay down the rights which we have during a significant disease outbreak. This is the second problem which the judicial developments during COVID-19 are struggling with. So now this brings me to my second topic, that is, when we say that these constitutional courts, the Supreme Court for that matter, the High Court, have to act as a rights court, then there is always a scope for judicial development, because these are the courts which are entrusted with the responsibility to protect the citizen's life.
Sir, your audio and video is paused.
Yes, am I audible? I guess there was a technical glitch somewhere.
Yes, sir, you are audible now.
Yes, I'm really sorry. So now this brings me to how the Supreme Court has been dealing with these. Firstly, I discussed that there have been certain matters which either the Supreme Court has taken by itself or the lawyers of that matter, the activists, starting from 7th of April 2020. Firstly, what we started with the petition of Aruna Roy and Nikhil Dey of an organization called Manzoor Kisan Sangathan, who had talked about, firstly, wages of the Manrega workers, that is the Mahatma Gandhi National Rural Employment Guarantee Act scheme, that those 7.2 crore workers, that is a big number, like 72 million workers who hold those cards, how would the Supreme Court step in as far as their wages are concerned? Then after some days, we had the migrant exodus. After some days of this petition, then there were petitions filed for fooding, shelter, and medicines for that for them as well. Then there is an interesting case that comes up before the court, before the Delhi High Court, and before the Supreme Court as well, wherein the central government had firstly taken a stand. Now, this judicial development becomes important because there always have been debate on how, to what extent the international treaties would be respected and implemented in India. So, in a case before the Honorable Delhi High Court, which related to the health workers and sanitation workers' facilities and their welfare, the government ultimately had to say that the government of India would be following the World Health Organization norms so that the safety of the health workers and the sanitation workers is ensured. Then, when we say about judicial development, one case which becomes important to talk about here also deals with judicial activism, wherein there are polarized opinions in the society today. By the Attorney General of India, Mr. K.K. Venugopal, had given a comment that the judicial activism which the Supreme Court has shown in the last 40 years is unparalleled. No doubt. The comment I personally agree with. But then there is another development which calls for judicial restraint, and that is in the case of direction by the Honorable Supreme Court to private bodies for free corona testing. There was a decision for free corona testing. A testing kit costs rupees 4,500. Somebody had approached the Supreme Court. The Supreme Court said that private bodies are also bound to follow that direction, which generally is not. Generally, I say, is not the case in a petition under 32, because that strictly relates with the fundamental rights violation. The Supreme Court said that we would make the private bodies also bound to that. Then there was certain uproar from certain section of society. There was a modification in the order. So this judicial development becomes important because this, even today, a month has passed after this decision. So even after passing of such a considerable time, this stands at the Honorable Supreme Court's judicial activism and the need to have judicial restraint. Then there have been certain other judicial developments as well. In the case of evacuation of people, now the government has come up with this Vande Bharat mission for evacuation. Previously, it was the Supreme Court which had come to the rescue of workers and citizens stranded in Middle Eastern countries, Oman and Iran. Then the Supreme Court said that they need to be evacuated with certain guidelines and precautions. Indeed. Then the Indian Air Force and the Indian Navy now has also started their operations. So this is why I have discussed this specifically for the reason because I said that the need to have certain provisions in the Epidemic Act to have those guidelines or those provisions for how would you prevent or control the spread of epidemic in India. So this is an important judicial development wherein the Supreme Court has taken a holistic view and had to try to plug in that hole. Then, because as already mentioned here by Dr. Jyoti, that my work also revolves around prison reforms in Tihar jail, there is a development because you see the jurisprudence after Sunil Batra's case in 1980s, the jurisprudence revolving around prison reforms, whether that was the Malimat committee, whether those were other reforms by the courts or by the directions of the Tihar authorities itself, the jurisprudence has not developed much. Maybe there are issues with the implementation of, for that matter, the lack of authority by the authorities. But today, the Supreme Court has ushered into this era of judicial reform again after a period of 3 decades, wherein the Supreme Court had taken the suo motu cognizance that prisons also need to be decongested. Then there were certain states which had jumped in and formed committees. The Delhi High Court itself stepped up. There was a committee formed under the chairmanship of Justice Hema Kohli. And then the decongestion of jails had started in Delhi. Now, this is a welcome step. The reason being this was done by the Supreme Court, I believe, 4 weeks ago. Even the decongestion had taken place, but there is one downside to it, that the Arthur Road jail in Maharashtra had certain cases wherein the prisoners had got infected by COVID-19. Why I am specifically pointing this out is because, as I said, I am dealing with the prison reform cases in the Delhi High Court. This is a welcome step by the Honorable Supreme Court taken at the right time. The phrase is taken at the right time because when we compare this step in the judicial development vis-a-vis the steps taken by the governments, which have not specifically led to the amelioration and improvement of the migrant exodus, then the Supreme Court has done a great job as far as the prison reforms are concerned in this case. Because this is one of the cases in Arthur Road jail in Maharashtra. Had these orders not been passed by the Supreme Court at that appropriate time, many other jails in India might have seen similar cases wherein the prisoners might have got infected by COVID-19. So this step in furtherance of judicial activism has been widely appreciated in the judicial development related to COVID-19. But then there is this one case which I specifically from India, there is this another case of Pakistan, which I talk about when it comes to judicial restraint. But then there is this one case related to judicial development that touches upon judicial restraint, wherein the Chief Justice of India specifically, and I'd read out the words from the judgment itself, that the Supreme Court on I believe that was Harsh Mandhe's petition, the human rights activist, wherein they had talked about the wages for the migrant workers. The court at that time had declined to interfere, and the Honorable Supreme Court had said, we do not want to supplant the wisdom of the government with our wisdom. We cannot take a better policy decision at this stage. We do not want to interfere with government and its decision for the next 10 to 15 days. This is another development because this has added to the debate of judicial activism versus judicial restraint, and specifically when it comes at such a critical juncture. Although this was the scenario 6 weeks back, today itself, that is on 16th of May, I believe the 15th of May, the Madras High Court has issued notice and sought a report from the central and the state government. So that development of the High Court might be another step that how the judicial developments now turn out to be in favor of the underprivileged and migrant class. So next, that takes me to the next subheading, that when we talk about judicial development, what is the way ahead? When we talk about Epidemic Act, when we talk about the Disaster Management Act, or the much controversial 144 coupled with 188, which we believe that are still possessing certain lacunas. So how do we expect the judicial developments, and what are the loopholes which we expect them to plug in? See, vis-a-vis 21, there are only 4 aspects which need attention right now. First is the liberty of the individual. Second would be the privacy of the individual. Third is the movement of the individual, and fourth is the property of the individual. The first 3, when we talk about liberty, that is 21, a fundamental right. When we talk about privacy, the Justice Puttaswamy judgment we have, which again puts it into fundamental rights. Again comes into Article 19, that is Part 3. The last one, property itself, is a constitutional right. So these 4 are the certain aspects which the judicial development needs to plug in. Now, this obviously would lead to some predictable and transparent decision making. Reason being, despite 50 days have passed from the lockdown and the pandemonium which we have ushered into, still we see that there is either lack of transparency in the decision making, or there are issues with the lack of implementation of the decision making, because there is a dearth of awareness. For example, if I take the current example of the migrant exodus, wherein the Supreme Court said that the government has told the Supreme Court that we are taking sufficient steps for migrants, we still see that why is the problem still subsisting? One of the major reasons is the lack of awareness and the lack of accessibility of resources as well to that. Now, compared the ED Act with the Disaster Management Act 2005. Before that, I'd just like to say that there is another bill when we talk about judicial development. A cue could be taken from the Public Health Prevention, Control and Management of Epidemics, Bioterrorism and Disasters Bill in the year 2017, which somehow sought to fill those gaps, which was by the Union Ministry of Health and Family Welfare. It was jointly prepared by the India's National Center for Disease Control and the Directorate General of Health Services. Although in a limited manner, but it had tried to address the problems for which we are today looking answers for in the form of a judicial development. That was in 2017, well, never saw the light of the day. That might happen when the regular parliament resumes. Till now, we do not have that bill in existence. So for current time, we have to be dependent on the judicial developments itself. Then the Disaster Management Act 2005. Now, this law has an advantage which the Epidemic Act did not have. Taken cue from Singapore, taken cue from Australia, Canada, and England. The DM Act of 2005 had set up the authorities on 3 levels. The central level, that is the national, the state level, that is the provincial governments, and the district level. And going a step further, this Act of 2005 had defined the roles of these governments as well, and the ministry's role as well. Now, this has given 3 cues for the judicial developments today. Firstly, it had focused on capacity building by setting up institutes. This is the first challenge that the Supreme Court is facing in judicial developments today, which although somewhat has been addressed by the courts by stating that there will be nodal agencies set up in states. So the Act had addressed the problem by setting up the institutes. Secondly, this Act had also laid down the provisions for financing the mechanisms. Because you see, when a pandemic hits a country, we cannot only rely on the general financial consolidated funds that we have. We generally need contingency funds for that. So this Act had made mechanisms for financing as well. And thirdly, the most important factor is the human response workforce is what this Act on a judicial development front had sought to plug in. Then, as I said, that liberty and property of a person is important for that matter. This Act also put a check on the government's action by prohibiting discrimination, and this has also provided the relief mechanism and provided the compensation for payments for affected parties, either when their premises were requisitioned and their resources were requisitioned. Because you see today, by the orders of court or by the action of authorities, there are many private premises also which the governments have taken up to either convert them into quarantine facilities or to convert them into treatment centers. So this act had also plugged in that, and I believe this is a welcome step in as far as the judicial development front is concerned. This next takes us to the practicalities of how the judicial developments and now are now working. And I'll just give a brief of this in 3 to 5 minutes. The first major development on that front has taken is that the technical setup has been stepped up by the courts. The physical filing have been converted into online filing. Then I have a comment that my audio is unmute. Am I audible?
Sir, you are
I guess
audible.
there is disturbance by somebody else. There is a disturbance by somebody else that might be creating an impact. So the first development that we see that when we talk about virtual hearings, so what we generally see it is that the virtual courts are being set up. Initially, those were only for restricted matters, bail matters, anticipatory bail matters, life and death punishment matters, stay orders, demolition orders. Gradually, the courts have expanded this definition of urgency and now have also started taking in the matters which were earlier on less priority of urgency. For example, as has already been mentioned, that I am dealing with the matters of 1984 NT6 riots as well. So, on the health basis, there are pending bail applications of certain accused in those cases. Now, even the Honorable Supreme Court had taken those bail applications on virtual courts via video conferencing, which I believe is a good step towards expanding the virtual courts and their arena. Then you see, starting from video calling to virtual hearing, there is a process which I'd also discuss when I talk about what are the disadvantages of these judicial developments. There is a process called mentioning of matters. The mentioning of matter, for those of you who are practicing advocates in the High Court or the Supreme Court, mentionings are taken up when there is an urgent matter to be brought before the bench, because the matter cannot wait till the time the regular registry filings are done. Now the courts have taken a proactive approach, and even mentioning of the cases is being done virtually through technology. So indeed, there are many advantages of this judicial development. Firstly, the formalities are done away with for the time being. For example, what the Delhi High Court and other high courts might also have done. Delhi High Court has come up with the notification that there is an issue with the filing of the cases which created a blockade in the virtual hearings and video calls. Was that how would you get the affidavits attested? How would you get the signatures of the people on the wakalatnamas? How would you access somebody who's already inside a prison? So these formalities have either been replaced by alternatives or have been done away with. And in case these could not be done away with, because affidavits, for example, a compulsory mandate in the Delhi High Court rules, or for that matter, the Supreme Court rules as well. So there is another important judicial development for practicing people and also to give some relief to the litigants, that the Delhi High Court has given a notification that you have a 72 hours window to get those formalities done. So those formalities have been done away with. This is the first important development. Then second development, which I'd say is a welcome step again, we have always been striving to introduce the concept of doorstep justice in India. So this is another advantage, that doorstep justice has got a greater push by the advent of virtual hearings and video conference hearings. And then indeed, on the environmental front, it saves a lot of time and a lot of paperwork as well. I believe the National Green Tribunal and the people associated with environmental law would appreciate that. But then this brings me to my last topic, that what are the disadvantages? Now, disadvantages are on three different ends. Firstly, what are on the courts end? Because being a practicing lawyer, we also have to see that how practically this would be feasible for everybody. So the first disadvantage I'd say, which exist on all three sides, be it the litigants, be it the lawyers, or be it the courts, is that we still are not equipped with technically robust equipment everywhere. I live in Delhi. I live in an urban area. I have access to laptop. I have access to cell phones. I have access to good bandwidth. The Supreme Court is in Delhi. The Delhi High Court is at a prominent place. There are high courts, because I have been a counsel in Meghalaya as well. There are high courts which are equipped with certain good equipments. Yes, but lawyers are an integral part of the system, and also the litigants, specifically when it comes to petitioners who are contesting cases in person. So this is the second disadvantage, that technically robust equipments are not so widely available that we could have a judicial development opening courts 100% through video conferences. This issue needs to be addressed, and this issue cannot be addressed in such a short span of time when the whole country is observing a lockdown. The third disadvantage that we have is also vis-a-vis the right to privacy in Justice Puttaswamy, coupled with the Ministry of Home Affairs notification, along with the fact that there is an ongoing debate of different internet platforms to conduct these video conferences. The courts firstly started with Zoom, that is a platform we are currently using. Then the Ministry of Home Affairs came up with a notification stating that the judicial work cannot take place on Zoom because there are privacy concerns. The courts abruptly had done away with it. Then the courts adopted Cisco WebEx. No doubt, this is a step which could have plugged some privacy concerns. But then we also have to take a cue from certain foreign countries, specifically the European side, that we need to have those robust platforms wherein this privacy issue is addressed. The fourth disadvantage that we have today is that we need certain dedicated, equipped, and trained staff as well. Now, since my major share of practice is in the criminal side, and these bail matters, or for that matter, those criminal matters are also being taken in the urgent cases, the staff who's either dealing with these video conferences, or the staff who's involved in the prosecution of these cases, or the staff who's involved even in the investigation of these cases, is either less equipped, and even if equipped, is less trained. For example, you can take a cue from the Cyber Laws. Information Technology Act came 2 decades ago in India. Even today, in a rural area, for example, in Uttar Pradesh, or even for that matter in Punjab, you go and file an FIR which concerns cyber law, you will see that there is a dearth of staff, and even if it is available, there are equipments which they struggle with, or there are training issues which they are still which still needs to be addressed. So this is the third disadvantage I'd like to discuss on this. Then indeed, I agree that physical entries have been banned. Now, this also comes with this point that yesterday the Honorable Supreme Court had made one development, that all the advocate on record who can do filing, there would be a demo for all those advocates on record. No doubt, this is a welcome step. But you see, when it comes at such a juncture, when everybody is under the national policy, which is wherein everybody is mandated under a lockdown, we say that geographical borders have been obliterated. This is an advantage compared to the fact that there are geographical foundations as well, wherein those people or those advocates sitting in different parts of the country who have to struggle with these developments. So I believe there still are issues on the legislative front, on the policy front, on the staff front, which needs to be addressed. The developments which have taken place are a much welcome step, but then there is a room to do more as well. this would be all from my side. I am grateful to you for your patience. I'd now like to request Dr. Saluja to take over. Thank you, ladies and gentlemen.
Hello. Hello. Hello.
Yes, please go on.
Haji Harpreet ji. Good evening.
Good evening, sir. Good evening.
And God bless you. Thank you
so much, sir. I am grateful to your whole staff for organizing this.
Thank you, dear, for sharing your valuable views and benefiting to all of us, our colleagues, our students, our other participants in this webinar. And you have highlighted so much from various angles of the recent judicial development during keeping in view the COVID-19. So far as what I think, there are three major acts which are dealing right now. But there's no need to go in the background of the judicial development, whatever the courts have done in the past. The question is that in the recent era, that during the last from March to till date, 2-3 months, whatever the judicial views about the protecting, enforcing our fundamental rights, that is the main right to life. In which way our country is suffering from life to life limits, whether they are poor, middle aged, or rich people. And this so far as filing the Supreme Court, the continuation of limitation does not matter, because it has always happened in otherwise in given summer vacations, limitation is automatically to be condoned. So if there is some extra situations, the limitation can also be condoned. So far as physical appearance before the court, it also does not measure, because keeping just to make the social distancing, just to avoid it can be done. And so far as this from online filing or online arguing is, I think it is not feasible and it is not proper. So far as the face-to-face argument and presentation is more important than online or video conferencing, whatever it may be, because there is some gap between the court and the lawyers, litigants, whatever may be. So whatever may be. But now the question is that in the present day circumstances, what the court has to serious views, or what is the judicial activism, what court has to stands in protecting and enforcing their fundamental rights, the human rights of its citizens, of its people in India. So there are 4 major acts which are dealing in this situation, COVID-19. That is the Disaster Management Act 2005 and Epidemic Disease Act 1897, and Indian Penal Code, and above all, Constitution of India, which is Constitution of India, which is the guardian, which is the grand norm at percussion of our whole of the laws, where we have to see the legality and validity of any law under the prevailing Constitution of India, whether under that constitution, whether that act fulfills its parameters or not, whether any government notifications, government guidelines fulfills its parameter under that law or not. And now this in the recent development, the Management Disaster Act, that is deals with a disaster. Now there are some peoples took this shelter of this act to avoid liabilities. That is a disaster. There is a total lockdown. There is no work, and whatever the Disaster Management Act says, that if there is a catastrophic mishap, calamity, or grave occurrence in any area, then disaster can. But now the Government of India, the Ministry of Home Affairs, on March 29, issued a circular directing to all the factories and companies to pay wages to its employees who are working for there. And now, recently, the Punjab Handloom Association has approved before the Honorable Supreme Court, filed a writ petition that this circular is a violation of Article 14, 19(1)(g), 21, and also challenge the legality of Section 10 of the Disaster Management Act, that due to lockdown, they are not able to work out, they are not able to pay the wages. So if, and the Honorable Supreme Court has put stay on that circular, if due to that stay, if they are escape from liability, then the workers from where they will not get wages, from there they will get their livelihood. The question, either they will go to starvation or they will go to far country suicide. Now, yesterday, one laborer had committed suicide in the state of Punjab, in a refinery company who has refused to pay the wages to its worker, and due to non-receipt of the wages, he has committed suicide, and the case has been registered against that refinery. So this situation may occur everywhere also. So this is the reason. And the development, then the Allahabad High Court had also set aside a notification of the district magistrate of Gazipur, Uttar Pradesh, banning azan on loudspeaker. The High Court, Allahabad High Court says azan is an integral part of Muslim religion. It cannot be banned because the district magistrate said that it affects COVID-19. How it affects the COVID-19? Whether the azan will spread the disease. It is how it is a joke. And this the Honorable High Court took serious view. And that, so like this, they are protecting human rights. On the other hand, there are so many workers, laborers are moving by road to their villages, and on the road they have died, accident to accident, otherwise also. And the Human Rights Commission took so much action. And apart from this is because under this, now the question is that in the present case, in India, there is an epidemic disease Act 1870. Now, this is not epidemic. Rather, it is a pandemic. There is a difference between epidemic and pandemic. This is not local, this is worldwide. So the government of India should have to amend its act of, that is the Epidemic Act, Disease Act, should amend. If there is epidemic converts into pandemic, then what reports are to be required? But since date, this act has not been amended. Rather, the court had to take so much, because there is no such need to file a writ petition to go to the otherwise, because there are certain newspapers, the court is having power, Supreme Court and High Court is having power to take so much action, because under the Disaster Management Act, the law is that under Section 71, that only the High Court and the Supreme Court can take cognizance. No any other court is having power. So that's why, if no any other court is having power and the court is not taking any action, so much otherwise also, whatever I had told you, that Punjab Handloom Association approach to the Honorable Supreme Court, escaping from liability to pay the wages to its worker, and challenging the circular dated March 29 of Government of India, issued by Government of India. If they will be, that petition will be allowed by the Supreme Court, Punjab Handloom, naturally they will become suicide, because they are no even earning on this point. So my question is that the limitation, whatever may be, whatever other thing also. And one thing, the Delhi High Court took a very good view that in the present day context, whatever the COVID-19 material which has been purchased by ICMR, Indian Council of Medical Association, at a very high rate. Now our country is going worst, and the mediocres, they are indulged in profit making. Whatever the Delhi High Court has, and when there is some dispute regarding sharing of profits, they had been denied, and the party approached the Delhi High Court, and Delhi High Court has said that whatever the very good remarks has been given there, that for the test, India for urgent emergency test through this country, especially in these present extraordinary circumstances of the worldwide pandemic, the country is going through an unprecedented medical crisis affecting public order. Now, we are go to die. We are on the road. We are on the deathbed. And the mediocres, the agents, they are indulged in profit sharing, profit making. This is a good development by our judiciary that have taken serious view about this and like this. And now since 1950, this is the very first time in the Indian judicial system that Supreme Court has constituted a single judge bench hearing. Because otherwise, before the Honorable Supreme Court, minimum 2 judges are to be required to hear a case. 2 judges, 3 judges, 5 judges, whatever, full bench and constitutional bench. But due to COVID-19, that there is some situations also there to deal with the urgent matter, that is the bail matters and transfer applications. That single judge has been authorized to hear the matter. A single bench has been created before the Honorable Supreme Court, and this is a good judicial development, so that to minimize, to reduce the pressure of the litigation over the court and to get immediate relief of that point. And apart from this, regarding liquor shops, now this during the period of COVID-19, you see, the persons, there are so many NGOs, Gurdwaras, or other some NGOs, or some of the even government providing food to the needy peoples. Because they don't have any money due to lockdown. But for purchasing the liquors, they are having the money. You have seen there are so many long queue. And this Honorable Supreme Court has also, when the government has ordered for this opening of this liquor shops, the petition was filed before the Honorable Supreme Court by Advocate Prashant Kumar through video conferencing. This Honorable Supreme Court had dismissed that petition, and by Justice Nageshwar Rao, that there are the court has a petition with cost that we cannot have multiple petitions like this. So, meaning thereby they applaud. On the other hand, this other judicial development, and if one aspect to see that they have allowed this liquors, that even you have money for food or not, but you must have money for liquor, and you have to enjoy your whole family. We have seen through newspaper that the persons are over drinking, and family is under starvation. So this is some differentiation and I think not good gesture for our development power, though it is a main source of revenue. So keeping in view the present day situation, and what from this month of March or January when this started, globally the peoples are coming from across the world, or from here to from other state to other state that the government has, and even on the railway track, so many people have been died. Petition has been filed before the Supreme Court. It has been dismissed. The court says that even if we are no more concerned with this, because this the government has already given Shramik trains, the people are why not going to. But the question is that whether they are having knowledge or not. Due to lack of knowledge, they are not ready to avail that facilities. And due to this reason, and the peoples are under forced circumstances, they have to walk by road, by foot to their villages because of reason of this want of money and loss of job. So that is the reason that, so in this way, I think the court has to take so motor action on this all episodes, whatever the country is during this period, and maximum, because the overall, the eyes of the people is before the court, that what the court can do. No money, because the political persons cannot give any relief, any NGOs cannot give the relief. Only the courts is the guardian of our constitution and guardian of our country that can give relief, then can take so motor action and can direct to the government. But so far in future, but the situation is that what we are going just by lockdown is not the solution, that to put the person inside and to lock, and there is no other infrastructures. So they go on the both sides, though life was important. That's why this human rights, the right to life, in the right to livelihood, right to food, right to movement, right to think, right to everything. They are so private, a very wide right to constitution has been given, guaranteed by our Constitution of India. And the court, either maybe Supreme Court, High Court, being guardian of our country and being guardian of Constitution, is duty bound to take suo motu action. And in this take, the judicial development should be there. Now, there are certain landmark judgment has been given by the Honorable Supreme Court and High Courts, taking a view and dealing with this COVID-19 so that no one can be allowed to take disadvantage of this situation, that is COVID-19, to escape from this liability or to put the person into the dustbin to die at whatever availing. So this should not be to be allowed. And I think being a judicial and being a lawyer, being a legal personality, I should like to suggest that in this semester we have all common efforts as to be required. And thank you to all of my friends joining us, and thank you Dr. Jyoti, who has taken initiative, Nazukji, and my other friends who have participated and given much valuable time. And thank you again, Harpreet ji, for sharing his valuable views. I think in future we will again meet. And
thank you, sir.
All
thank
the best to all of you, sir. Thank you.
Thank you so much. Thank you, ladies and gentlemen. Have a good day. Harpreet Singh signing off. Thank you for joining us. Thank you.
Thank you, sir.
Thank you so much, sir. It was very useful. Now, participants would like to ask you some questions.
Okay.
You may type the question so that there are less audio projection in case you want.
Sir, can I ask the question now?
Yes, please. Whom that question is directed to, me or Dr. Saab?
To Advocate Harpreet Singh Hooda, sir.
Yes, please.
Sir, my question is regarding the directions which were issued by the Supreme Court a few days back, that the under trial is accused of offences which contain punishment of less than 7 years be released.
7 years. Yes.
Yes, sir, they should be released. But the problem is, sir, the offences which contain the punishment for 7 years are bailable offences. So most of the prisoners, the accused persons, should have been released on the bail. So there will be very few number of persons who are under trials in these offences. So, sir, will this kind of direction serve our purpose? Will this serve this purpose?
Sir, firstly, you need to see that those are not bailable offences per se. Bailable and non-bailable, the difference is that non-bailable are the offences wherein you have to approach the court to seek a bail. So, secondly, when you say that if an offence carries a sentence of 7 years, then it has to be a bailable offence, is not true, with all due respect. There are non-bailable offences as well. Secondly, the Honorable Supreme Court, while these directions have laid down those guidelines to put a way forward. The next step is that a committee would be formed, which has been formed by the Delhi High Court. I know it might have been formed by other high courts as well. The next step is that a committee has to be formed under the chairmanship of a sitting judge of the High Court, which has been formed by the Delhi High Court. Then it has to the people who seek the benefit of this guideline have to approach that committee, in which case people have approached this. Only then the court on case-to-case basis would take a call that whether this person has to be given the benefit of these directions or not. And in case he gets it, the maximum term here in Delhi, I know from the Delhi High Court, is 45 days. I do not know about other high courts. So, firstly, saying that all of those offences under 7 are bailable is not correct. There are certain non-bailable offences as well. Had those been bailable offences, you would have got the bail from the police station itself. So, there are non-bailable offences as well. And you, even if you want to avail the benefit of those guidelines, you have to approach the committee of the High Court, which would then direct you to, which would then see that on case-to-case basis and then take a decision. That is not a mandate that Mr. X approaches the committee and he gets the bail by default. No, that is not the case. Any other question?
Sir, one more question.
Please.
Sir, the question is regarding the FIRs which have been registered under Section 188.
Yes, please. I knew this was coming. Anyway.
Sir, regarding the which the ex-DGP of the UP Police,
Vikram Singh, Mr. Vikram Singh. Yes, please.
Sir, what we need, if I am not wrong, what we need in 188 in these FIRs is that there should be a complaint made by the PM or
absolutely right. You're absolutely right.
So will these FIRs stand judicial scrutiny? Because
to answer this question, because I said my major share of practice is in the criminal side, and also because this webinar is being recorded. But please let me put my honest opinion on this. He had approached the court. They had sought a blanket relief, which I believe the court has not granted. But on each case basis, as you have rightly pointed out, and I'm impressed by it that you have pointed out a very technical flaw, that there could be FIRs. And from my little understanding and experience dealing with the police department and the criminal justice system here, there could be certain cases where there would be many technical lacunas in these FIRs. So you would surely find that there in certain cases, these might not stand the test of judicial scrutiny. You have rightly pointed out. But till the time the trials are there, or till the time they reach to the stage of charge framing, or somebody approaches it for questioning, till the time we cannot comment on that in a definitive manner. But yes, you have rightly pointed out, there is a big doubt whether those would stand, all of them would stand judicial scrutiny.
Thank you, sir. Thank you, sir. Thank you very much.
Is there any other question?
So I have one question to you.
Yes, please. Is it to me or is it to Dr. Shah?
Yes. To you, Mr. Sir, my question is actually regarding the mandatory imposition of the Arogya Setu app.
Mandatory mandatory download of that app, the government Arogya Setu. Yes, please ask.
Yeah, so as per the government's pandemic management strategy, as you mentioned earlier, the National Disaster Management Act has become a sort of an umbrella clause.
Right.
And this permits the government to issue all sorts of guidelines and directions. Right. However, Part 3 of the Constitution requires that even before we get to the discussion of whether there is a rights violation, there must be a law that authorizes it.
Absolutely,
in your view,
you're absolutely right.
National Disaster Management Act sufficient in its scope to be such a law? Because I mean,
to be such a law
for
justifying the mandate of downloading this.
Yes, absolutely.
Well, see, for example, yes, please. I'm sorry, please.
Yes, sir. So, for example, the High Court of Kerala recently disallowed the government's direction to cut salaries without any specific legislation.
Right.
So, can such a logic be used in this circumstance as well?
Right. So, see, when we talk about this, the first aspect I'd like to deal with this, I'd answer that question on divided into two subheadings. Firstly, I'd say that since already petition has been filed in an honorable High Court and the High Court has to take a call on this. So what I'd say from now onwards is my personal opinion.
Yes,
secondly, you have rightly pointed out there needs to be a legislation backing it. Because, for example, if we talk about 21, which talks about procedure established by law, then 1978, Indira Gandhi, and then there are hundreds of judgments, just, fair, and reasonable. So you have correctly pointed out that this NDA, the Disaster Management Act, is being used as a blanket legislation, which, in my personal opinion, I disagree with. That it cannot be and should not be. Also, because of the legislations carry, and also because of the violation of right which it may entail. So this mandate to download this app has to be tested on the ground, because you see, it not only is interfering with 21, is also interfering in one or the other way with 19. So 19.2, that firstly, when you say that you mandatorily have to download it, the first question would be whether it is a restriction or not. The answer would be yes. The only question this whole discussion would narrow down to is it reasonable in the context of fundamental rights we have? In my personal opinion, this mandatory downloading clause is bit overboard, bit overzealous. I would not touch the point of privacy concerns because there is a long debate on that. But yes, I would somehow agree to you that there needs to be a legislative plug into this in case the government wants to mandate it. Until and unless that gap is filled, I would reserve my disagreement with this mandate of the government with all due respect. But since, as I have already said, there is a petition pending in an honorable High Court, so we would await the decision of that petition.
Okay. Thank you. I just have one more question. Since you stated that you work on the criminal side.
Yes.
Yes. So during this pandemic,
right.
I mean, there have been various theories of criminology that have developed. That
right.
Individuals commit crimes to send a signal to the state that the system that they are forced to live in is inherently biased against them. And right now, in this present circumstance, on one hand, the state prohibits a class of citizens from working and earning their own bread. And on the other hand, the state fails to fulfill their basic requirements, right, through the lockdown. So can we say that the state has left them without any conscious choice? Can we say that in this current circumstance of existential crisis, how do we trace the mens rea of their criminal activity?
I would wholeheartedly agree to the intention with which you have asked this question. Dr. Saluja had rightly pointed out. On one hand, you say people have to stay inside homes because the government is trying to preserve their right to life. On another hand, you say that the government is not able to provide you everything, hence you have to take care of yourself. Dr. Saluja rightly pointed out this point. When you talk about mens rea, the problem with our criminal justice sometimes is, as has also been pointed out by one of the judges who had just retired last week, that this criminal justice system, he felt, is more inclined towards the privileged and the richer class.
Yes.
So I'd say that when it comes to proving their mens rea for that matter, because the actus reus is something the state would say is based on facts. The state in a mechanical manner would say, yes, there is an actus reus on your part. The state sometimes, because the prosecution, when you see that there is somebody who's an underprivileged person who's fighting to defend himself against this gigantic machinery of the state, everything revolves around the point of mens rea. The question of an effective legal representation is a vital aspect of criminal justice system in a country like that. I hope that it gets addressed, but I do not know, maybe 10 years later, 20 years later, or maybe not even 50 years later. But yes, this is a bit of a gloomy and sad aspect of our criminal justice system, wherein the underprivileged somewhat have to be at the receiving end of disadvantages of our system.
Okay.
Good evening, sir.
Thank you.
Good evening, sir.
Yes, good evening. Good evening.
Yes, sir. My question is just for Advocate Harpreet Sura.
Please go ahead.
Yeah. So recently there was in the news that the state is imposing some COVID cess upon certain commodities, and primarily it is upon the liquors. So since the talk and the webinar pertains to the judicial developments as far this epidemic is concerned, so what should be ideally, or there is a duty which is costed upon the judiciary at this moment in time, particularly upon the High Courts and the Honorable Supreme Court, to take in suo motu cognizance of the facts where there is where the subject is being vexed, where the subject, as has been highlighted by the Salheen also, as you also pointed out, on one hand, there are certain restrictive measures being effected, being brought in place by the state, but on the other hand, the basic needs of the subject are not being taken care of. So just regardless of that, so how far the judiciary. What ideally the judiciary is required to be done at this moment in time. At one hand, when the people are facing so much of trouble and problems because of the epidemic, on the other hand, they are being vexed with this excessive COVID cess.
So, is that question specifically in relation to the rights of the rights and the problems faced by the people vis-a-vis the taxation regime which the government is imposing? Is that question specifically directed on that?
Not exactly, sir. I mean that there is a role for the judiciary to play in such a situation where the state is acting arbitrarily. On one hand, they are just inclined every next day. There's a press conference being held by the honorable finance minister of the country. But on the other hand, recently we could see there was an hike in the petrol prices, diesel prices, gas prices, and now there's a COVID cess. Isn't there in duty upon right now, upon the judiciary to come forward and take in suo motu notes of these illegalities, which I...
Yes, this has been addressed by Dr. Saluja, and he has said that yes, there are judicial developments needed in this place, and I'd like to extend this by saying that, now this is completely my personal opinion, when there comes an opportunity that the courts have to come to the rescue of citizens, and specifically this becomes more relevant in such tough, distressing times, I believe that yes, as Dr. Saluja has also said, that I had also agree to you, the judiciary is not only duty bound, but as it stands the guardian of our rights, there has to be a more proactive approach from the judicial side. So I'd say that when it comes to balance those rights, and also the state on one hand would say that we have to raise that and we have to impose those cess because we are hit by an unexpected situation. The state's stand is justified, but it is justified only up to a restricted limit. The state cannot go haywire in any direction and impose anything and everything on the citizens on one hand, stating that we have been hit by an unexpected situation. So yes, when it comes to the courts, I believe something more is to be done to restrict the executive authorities from trampling down upon the rights of the people. And I had pointed out when I said what I expect out of judicial development, I said that there are 4 fronts which I believe the courts needs to work on: liberty, movement, privacy, which are fundamental rights in Part 3. The 4th one I said was property, which still is a constitutional right. So yes, I believe the courts needs to have a more proactive approach. Is that all?
Hello.
Yes, I believe we are done.
Is there a question from anyone? Hello, Raju.
Sir, no, there is no question from
No question at all?
Yes, sir.
Now we have to sum up.
Yes, sir.
ठीक है. Okay, to thank all of you. And again, I express my gratitude to Shri Harpreet ji.
Thanks, sir. Thank you so much.
Who has given much more valuable time to us. And I think in future, whenever we need your requirement, you will be available to us. And to
anytime, sir, anytime. I'm so grateful to you.
I am again thankful to my HOD, Dr. Jyoti ji, who has taken much pain to organize all these things and to very good channelize all these things. He is very active, our HOD. Without her, I am nothing. So here all time supporting us. Nazik ji, all time very actively working. So this is our overall team. So I am again thankful to all of you. Again, I am very much devoted to you, and thank you, Dhriti ji.
Thank you, sir. Thank you, Dr. Saluja. Thanks to your whole team. Thank you to all the participants.
Bye
Thank you, ladies and gentlemen.
Thank you, Advocate Mohammed and Dr. Saluja. Thanks everyone for participating. Thanks.
Okay. Bye bye.
Thank you.
Okay, thank you, sir.